A report was released by the state's highest court today. The SJC had asked a former federal prosecutor named Jack Cinquegrana to study the district court system and how it handles drunk driving cases in the wake of a Globe Spotlight Team series a year ago. What we found is that a huge number of people who are charged with operating under the influence don't have a traditional trial before a jury. They have a trial before a judge, and that 4 out of 5 motorists who go bench are acquitted by judges. The report commissioned by the SJC lists several potential remedies. One of them is for the judiciary to consider whether it should change the rules about how criminal defendants decide to waive a jury trial. So what they seem to be getting at is the notion that it should be harder for defendants to, at the very last minute, when they see someone they think is going to be a sympathetic judge, to say, "Oh, I'm going to go bench." They also recommended some other changes. They recommended that judges get more training in terms of how they handle scientific evidence. They also recommended something that addresses kind of an arcane area of the law. A lot of defendants will claim at bench trials that they might have been at .08, which is the threshold for being intoxicated, at the time that they took the breathalyzer test. But they sometimes say that maybe an hour earlier or a half hour earlier, when they were stopped and they were driving the car, they weren't at .08 because their bloodstream hadn't really absorbed the alcohol. This report says that they could find no explanation for why in some places like Worcester County there are judges who have a nearly 100% acquittal rate. For the Boston Globe, this is Jonathan Saltzman.